Hi, everyone. So first, I'm a lawyer, so this is not legal advice. This presentation is structured, give you an overview because it might get a bit dry for some people because there's not a lot of code in this presentation. So we're going to first look at the fundamental right of privacy. Then we're going to look at the importance of privacy, especially also to blockchain. We're going to look through surveillance perpetrated through the FATF regime. We're going to look at what's happening in this moment. I actually rewrote this presentation because of the indictment that came out recently against Tornado Cash. And then we're going to look at what we should be doing going forward. Some practical things, some are more ambitious that involve legal steps. So once upon a time, all of you know we had some privacy. And this was mainly due to the physical realities of our lives, not necessarily because there were like legal rules on this. But even in the Middle Ages, a person's house was considered their castle in English common law. Through the different ages, this was the basis for the development of a human right for privacy, or in the US sense, more of a civil liberties right of privacy. This became very, very clear after the Second World War, where people realized that that there were human rights and they needed to go, privacy was one of those, and needed to go into the Universal Declaration of Human Rights. And you see the text here, which is basically, this text repeats everywhere, which is, no one shall be subjected to arbitrary interferences with his privacy, family, home, and correspondence. This was updated over the years, and that you have the right of protection by the law for this right against any of those interferences. This is repeated again in the European Charter on Human Rights. This document actually addresses mainly EU institutions and how they have to act towards the citizens of the European Union. Again, it repeats it has it updated slightly. It's communications now, it's no longer just correspondence. You also have Article 8, which is the basis for all the data protection rules. And what you see is that data needs to be processed with the person's consent. That's being misused by the GDPR a bit. Then you have the European Charter of Fundamental Rights. This was passed in 2000. Again, same things. Wait, where am I? The European Convention on Human Rights, it has a very similar text. And that the interferences needs to be proportional if something happens. Again, data protection, we don't need to spend too much time on it. You're very, very aware of this. Now, when you look at this, why am I going through this is because you need a different approach when you're actually fighting for privacy rights in the EU and the US. So in the US, there is actually no explicit right for privacy. All of it comes down to the Fourth Amendment, which is that there are no illegal seizures of a person. And courts have inferred some form of a privacy right in the US. The same is the case for data protection laws. It's sectorial, it's fragmented. There is no data protection law on a US federal level. There are, of course, California and a few other states that have them. And when you see all of this, whether this is EU and US and also other countries, is that financial privacy is privacy. We know this. This is often, however, forgotten. So when people talk about privacy, they don't think about financial privacy, but this is actually really what we need in our space. So you have this very nice quote from Twitter: "Public blockchains today are the epitome of financial surveillance. State-of-the-art blockchain is a law enforcement wet dream." That's totally true. And we know this, and you guys especially know this. What we get is surveillance, extortion, and absolute public data exposure. So there have been amazing projects, including DARKFi, a few others, that have dealt with this, and they're working very hard on trying to establish blockchains or blockchain solutions to help us retain our fundamental human right of privacy. Now, while we went through this list of wonderful legal statutes and conventions, something else happened at the same time, and that's basically is this. It's like the G7 in 1989 set up or birthed this organization called FATF, Financial Action Task Force. The funny thing is about FATF, it started out very small. It was just supposed to look into money laundering in relation to drug trafficking and offenses. And the idea, maybe at the time a novel idea, of course for us it's long, we deal with this for the last 30 years. It's basically use the money flows to detect and prevent crime. So they set this up, and over the year, every time when there was a geopolitical event, this was expanded. And now it's not just money laundering, it's drug trafficking, human trafficking, tax evasion, sanctions. They deal with a lot of things. When I speak to FATF about people, they usually think this is an international organization with formal legal credibility, not just soft law credibility, legitimacy. And what has happened is we appreciate this in the blockchain space because it's what we would call an illegal setup. It's wonderful because it's very hard to actually have a legal challenge against this. So they do not have an international status, a statute, a convention like all the other organizations. Instead, it's all soft law. And there is, because of this, you have influence with very little transparency and accountability. You cannot just attend a FATF meeting. I tried to do this before. You have to be invited. And of course, you're only invited if you're someone who they want to talk to and not someone who criticizes them. And I might be a bit harsh because obviously there are very good reasons to track money flows, to identify crimes. There's some horrendous crimes being perpetrated, and we need to do something on this planet to deal with this. What they do is also they give out these recommendations. They're like 40, and one of their most famous rules is the travel rule, and that one is currently inflicting or being applied to crypto. This is happening right now and next year, and it's going to get worse. So let's just look at quickly what FATF has actually achieved. These are numbers. They have to be taken with a grain of salt. It's very hard to estimate the numbers, but it doesn't really matter whether it's 2% or 1% or 0.1%. It's very tiny. So when you look at worldwide illicit funds and as a proportion of criminal proceeds, you get to minuscule number. This is but a rounding error in the accounts of any of those criminals. So they all retain their property. It's like 99%, and maybe 98%, and someone who wants to argue with me about the numbers might come to 97%, but they're really high. At the same time, this regime, when they set out, they didn't put a measure in place to measure what is success for the regime, what is success for the international compliance industry. And there's specifically no question asked or instruction to look at what things cost. So they're really expensive. So you have 300 billion in compliance costs. And a lot of you guys who are dealing with raising funds know this really well. You need to sometimes, a lot of countries, you need to hire an intermediary who takes a percentage of your funds from the money you have raised. The banks basically have made the majority of these costs. And well, you have like 8 billion in fine annually against those banks. And what do you actually get out of that is about $3 billion of raised funds. The numbers they change from year to year, but you can average it out at that number at the moment. So there isn't really that much evidence that the compliance industry does much against the crimes that are happening. Like this whole idea, this experiment, some people might say has entirely failed. And what you actually need to do is you need to go back and consider how you can reduce those crimes. And all at the moment is done is go after the money flows, and the cost of that is outsourced to the industry and the persons, and actually our financial privacy. So this is happening at the same time, and that has very much taken over our right to privacy. So from a more practical level, what you have is the travel rule. So you have to basically give all the data, where you live, where you get the funds from, is this through employment, whatever, what's your status, passport number, date of birth, all of this data from the sender to the beneficiary institution. And they need to, in a chain, they need to keep this information. And this is expanded now to the crypto industry. We basically, you have to do the same thing. So every transfer has to have this information. With the war in Ukraine, there has been, it seems, or it's the impression I get, that the regulators have been in a haste to basically ensure that they can make these rules more stringent and apply them to crypto, because they were worried that Russia is using crypto to circumvent the international sanctions regime. The other thing that has happened because of the compliance lobbying, or what has the compliance with FATF standards and recommendation worldwide, is that also the criminal provisions of like charging for money laundering and anything around it have become much more vague, much more severe. And you can see this in countries such as the Netherlands, where Alexei Pertsev of Tornado was arrested last year, is that in the Netherlands, it's an all crimes approach, which means the underlying crime can be anything. It doesn't have to be a list of things anymore, more like truck trafficking, arms trafficking, or anything, which is the more conservative approach to this. You basically can use any little infraction and you get money laundering charge if you want to. That, of course, makes it much easier to charge for money laundering and similar offenses. So what is important, however this is likely to change, is that MiCA, which is the markets in crypto asset regulation, is that it does exclude peer-to-peer transactions, and it only applies to crypto asset service providers, or what internationally are called virtual asset service providers. However, the definitions of what this is very wide. So even if you have a front end, you might fall under this definition. And in MiCA, crypto lobbyists have succeeded, with a lot of efforts, to get a full decentralization exemption into this. However, what is full decentralization? A lot of legal experts have already said that this is literally none of the projects, or very few of the projects in the crypto space that do this. They're also going to set up a public register of non-compliant service providers, so with which European ones are not allowed to interact. So if you have, for example, crypto event, you deal with one that is based somewhere else, let's say in Thailand, they might not be, you cannot probably not off-bank those funds into Europe. So obviously none of the European ones want to be on this. There's also, which is different, now in the European Union, it seems like that we like to be world champions in regulation, and so they go above the international standards, where there is like a de minimis limit of 1,000. And moreover, you have like unhosted wallets. They require what they call extra due diligence or enhanced due diligence, where basically it's likely that many of the centralized exchanges will decline to onboard more than a few, or if at all, any unhosted wallets, like the real wallets, basically. So they have to do all of this, and the transfer of fund regulation, as it's currently drafted, and was drafted very fast because of the the Russian invasion in the Ukraine, is very vague. The standards are very vague, and there are good reasons to suggest that it's actually not in compliance. It breaches the charter, the European Charter, because it's so vague. There are some activist lawyers that are currently trying to sue against the legality of the transfer fund regulation. So, of course, we all know this is not the only aspect that is currently subject to like a war. Like there's a new war on encryption through the child scanning regulation that is being debated right now. And you get like, this is supported by posters like this. I mean, this is a US one, but it's very similar in the European Union. So it's not the only thing where we are subject to a privacy infringement, but it's a very important one. So all the privacy protocols that are currently being built are really like, they need to look into this, because it's pretty serious what's happening right now. And you cannot assume just because you're building a privacy protocol and because you have privacy rights, you're safe. So in the European Union, there have been some success on this. Some people say it's not success because it's horrible what happened. So in this Luxembourg registry case, the European court struck down the provisions on the disclosure of ultimate owners of properties, which was supposed to be available to anyone in the public. So the problem with that, and there was another presentation yesterday on this, on the security, is you own a house somewhere, some people will just get all your data by just going to the register in the relevant countries and checking where you live, how old you are, what you do, what your passport number are, all these data. So that is a security problem. And the European Court recognized this as a problem because it's built under the auspices of transparency, but transparency is against the institutions. So it seems that, at least from a European court perspective, the EU agrees with the cypherpunk juxtaposition. So privacy for the weak, transparency for the powerful. That is at least something. So there are advances, there are things that can be done to help us. This is one example, court case. A lot of people around me thought it was so horrible that this went through, but there's a good reason. Privacy is more important than the transparency of institutions, and the transparency of institutions shouldn't be extended to the general public. So now there's been a talk this afternoon on Tornado Cash, and it was about the technicalities of Tornado Cash. So my presentation no longer looks at the technicalities of Tornado Cash, but I'm actually looking at what is being claimed, what do we understand, what can we do out of this? What steps can we learn out of this? And it's basically, this is just what happened. I think most of you are very aware of what happened in Tornado Cash. There was an indictment on the 23rd of August. It was unsealed. It was, I think it's a July indictment. And then what happened, after Alexei had been arrested last year, now also his co-founders, Roman Storm and Roman Somenov, were also charged. Roman Storm was arrested, and then now he's on bail. And Roman Somenov, who is actually a Russian citizen and not an American, was put on the sanctions list, together with all these wonderful, real big criminals, basically. Like he's a open source developer, and this happened, right? So when we look at the indictment, it's interesting what they are doing, which basically they're establishing that the three of them were operating the Tornado Cash. And how did they do this? They basically said, well, you paid for the interface that actually redirected to IPFS. You used the credit card for your GitHub account, and you had a financial interest to pump the token after March 22, when you established, together with a DAO, a relayer system, which I'm going to go a bit more into. Also, they paid for the node operator in the US. So that was used to basically say, you control Tornado Cash, and because you control Tornado Cash, you can be charged for running a conspiracy to operate an unlicensed money transmitter. I'm going to not look much into this. There's a lot been written on it. Conspiracy to commit money laundering, and conspiracy to commit sanctions violations. So the conspiracy to commit money laundering is very interesting. So we're going to look at this because it's related to FATF and how wide this stuff has become. There's also, which I said should I say before, is the communication between the three of them was intercepted, encrypted chats on Signal and Telegram, and those chats were I think any lawyer would have probably told them you shouldn't have those chats, and if you have them, maybe use a automatically delete function. But basically, it was intercepted. I have not seen the indictment against Alexei, because in the Netherlands, you do not do this usually, and Alexei has not released it into the public. So that's why I also cannot comment on that, but I do assume it's very similar to what's done in the US. There's also needs to be mentioned that in the US, there's basically a bit of a higher threshold on these charges, so they needed those chats to actually prove their points, or try to claim to prove their points. So there was an agreement between two. What's also important to note is these are all conspiracy charges. They're usually used against developer, and I see them being used more against developers, which basically charging a person of conspiracy, it's easier from an evidentiary and procedural perspective in the US and elsewhere, because then you can use whatever another defendant said against the other defendant in the proceedings, which is why the chats are so important. So this is like what they define conspiracy. I don't need it that much, but basically what they said is that, well, let me rewind. In March 22, what Tornado did is they set up this relayer system. So the relayers were there to give extra anonymity to whoever used Tornado, because on Ethereum, you do need to pay gas costs. So if you actually wanted to take your funds out, you would have to have already had some Ethereum in the account, which defeats the point against like severing the link between your two accounts. So you had these relayers who prepaid against the fee taken from your Tornado funds, the gas fees. What they did is they used they created a decentralized system where basically anyone could apply to be a relayer. You had to bond Torn tokens to be able to be selected as a relayer, and the higher your bond was of Torn tokens, the more likely it was that the algorithm choose you to help a person to take the money out of Tornado. So this system also pumps the token, and what the US the prosecutor said is that the purpose of this was to pump the token and basically give an indirect, like basically give a benefit or payment to the developer by increasing the value of their tokens. And in Tornado, they had quite a high amount reserved for themselves. Basically, 24% went to them, and 6% went to one of the investors who is also based in California, VC. That is a very high number from a crypto perspective, actually. And because they set up this relay system, the indictment only starts in March, because this is what they needed, or they thought they needed. That was sufficient to prove that they had this interest in they had this economic interest that was needed for the charges. On the other hand, what you can also say is actually that the relay system, it was set up, it was quite a decentralized system. Anyone could apply to be a relayer. It wasn't chosen by the Tornado Cash founders to have they didn't, they didn't choose them, which would have been even higher control. But what they basically wanted to get them, and they did find something where they thought is most likely to get them. Whether this is going to hold in court, not so sure. We're going to see this. So the money laundering charge mainly relates to concealment. And one other thing that is, I think, valuing quite highly against them was that why might they be able to establish this? I'm not saying they will, because there's a lot of reasons against it, because it's so indirect, is that after the sanctions were announced, the founders allegedly went to Binance, hiding under some Russian person's account, or like using a Russian person's account to get out $8 million of value from those Torn tokens, and they divided it by 3, and this is what at least is alleged in the indictment. I should also add that while this is not an indictment, a lot of times people get what can be used against developers of privacy coins that allow for illegal mixing or privacy, basically mixing of criminal proceeds, is the aiding and abetting charges. This is often used. It's not used here. They didn't need it. I put here a list of things that I think are noteworthy about it. Let me see whether I forgot mentioning something. You had investment. You had 24% for the founders. The UI was controlled by the team, which is the biggest problem. This is how they establish operation. They did receive complaints from law enforcement, and they answered them declining. Generally, do not answer first ask your lawyers what to do on this. This is what I advise, at least usually. And I mean, the chats actually proved that they knew that OFAC, the Office of Foreign Asset Control, charged, like sanctioned the Lazarus Group, and that the accounts, which were the wallet addresses that were routed into Tornado, the funds through the wallet address were routed into Tornado, that they were from the Lazarus Group, and they talked about this in their chats. Something very perverse about that is maybe they shouldn't have been that concerned about legal, then they wouldn't have discussed it in their chats, and then, they couldn't have put this in the indictment. I'm not sure. This is a very cynic view of this. So when you look at what's happening right now, when you look at like the transfer of fund regulation and the court cases so far, you should focus on building P2P because it is still excluded. Do not have a front end. Don't have a GitHub. And if you have all of those, don't pay with your credit cards. The other thing is there are opportunities to defend against what the infringement and the surveillance regime. It's quite hard, but one is basically sue against the laws, like the legality, do what they call in English judicial review against what is being passed right now, because a lot of that is done in haste because of geopolitical events. And, well, we should really consider reforming the compliance industry, maybe refocus on stopping those underlying crimes, and not only believe that the money flows will be sufficient because the current system is so dysfunctional. Obviously, there's quite a lobby in favor of the compliance industry. They make a lot of money. And that's it. Thank you.
Thank you so much. Is that mic? Yeah. Thanks so much for your talk. It was great. Does anyone have any questions for Silke?
Hey, Silke, thank you for the presentation. And I gave the one earlier that's very much not from a lawyer perspective. So it's good to see the alternate and more, I'm sure, legally correct presentation on Tornado Cash specifically. But my question around Tornado Cash was, and this is something that I highlighted in my talk, there's no mention in the indictment of whether or not the Lazarus Group used the UI that Tornado Cash was running, or if they just used the smart contract directly. Do you have any more thoughts around like how that could play in this case, or how that could play in even from the perspective of future developers building tools like this?
I think it's, and this is now me thinking about it aloud, right? So I did see that also, that it isn't mentioned. For their argument to establish that they were operating and therefore responsible for Tornado Cash, that is not necessary because they had the UI. And probably most people did use the UI. I mean, Tornado actually used IPFS, they redirected directly every time to IPFS. So I think this argument should be made, but I'm not sure whether it's going to hold. Especially, I mean, you could potentially argue because that smart contract, I think it was the 100 ETH pool, they routed it through, was immutable. They used it directly, and therefore the founders should not be engaged with it. However, that is a good argument. I also think, however, what you need to ensure is that you can argue that they weren't running Tornado Cash just because they were having the paying for the interface. Because we all know how difficult this is. Get someone to pay for the interface. Often people have to use their personal credit cards for this. And at the time, yes, there's radical. This is great, but at the time, I'm not sure it was available. And people people make the same mistakes all the time, right? They use convenience as inconvenient. We're paying this secrecy tax of inconvenience tax with this to get privacy, and people cut corners. So, but yeah, I think this argument should be used. I can't really comment on how successful it's going to be. I do not think that it's a done deal, this prosecution. I mean, in the US, they usually hope for a settlement down the line because of the costs involved in defending this. So if you want to support the developer, you can support their defense fund. It's pretty expensive. So, yeah.
Thank you. So, and my other question is that, okay, so these people are developers of Tornado Cash, but they're also users of Tornado Cash. And as far as I know, the sanctions mean that basically all Ether that is coming out of the Tornado Cash smart contracts is considered tainted. And is it retroactively true, even for all the funds, or is it only Ether that came out of the Tornado Cash smart contract after the sanctions were imposed?
It's not retroactive, however, in practice, so it's not retroactive, and there must be also make some distinction. This only applies for US person. This definition is quite wide, but anyone who's not a US person isn't really covered by the sanctions. So if a Dutch person or German person takes out the funds after, there isn't any criminal offense or administrative offense that is arising out of that. However, what happens is that exchanges, they don't distinguish between where someone is from, where someone is based, whether someone is a US person, because the definition of US person is wide. So they do it easier, and they err on the side of caution. So if you would then put these funds into an exchange, or even on a platform like OpenSea, you will not be able to use it, or try to use it even on Ethereum. They prevent you, like some of the wallets prevent you from seeing your balance or with this actually. So it is only for US persons, but not for everyone else, but it has been enforced for everyone else. And in relation to the Tornado Cash founders, they, in the indictment at least, you do not see that they used it. All they got is, when they started the DAO, the Tornado Cash DAO, they got each 8% of the Torn supply vesting over several years. So they had the Torn supply, and they cashed out on some of this using Binance. So there weren't, and also only one of them is American. Roman Storm is American. So there wasn't a problem based on that argument, there wasn't a problem for the others.
Any other questions?
Yep. I have a question related to the EU chat control. Like you mentioned earlier, you quoted a lot of, European Charter of Human Rights and all that type of stuff. Right now, in the EU, there's like a proposal out there against, it's called like the CSAM, whatever regulation, it's child sexual abuse material. And essentially it would force every platform that is offering communications, that is like chat messengers, but also email, video chats, whatever, to essentially automatically scan every communication for quote unquote illicit material. And that's something that was supposed to go to the parliament like 2 days ago. Like this is not something down the road, like long time.
Yeah, it's going on right now. This is
it's happening right now, and it's probably gonna, I don't know, be approved within the next couple of weeks.
Yeah.
When I see what's actually written in all those charters, how is it possible that such a regulation from the European Commission is even on the table, which would require like the surveillance of 450 million people in Europe? Like, how is there like not something that you can like have a legal challenge before this is even on the table, and like not wait 7 years and go through the court system?
I think doing having a legal challenge before it's actually passed is difficult because there are a lot of changes that are happening in relation to the chat control law. I do expect if it goes through like it is right now, there will be challenges because they already showed that it isn't technically possible to do this without violating the right to privacy. It's a huge infringement because and experts are actually unified on this. What I read recently, and I cannot confirm whether this is true, but basically they looked at like the financial interests, follow the money flow. Let's just use what FATF does, right? So you follow the money flows, and you have some very powerful AI companies behind it that have been pushing for this because it's their software that is going to be used. So there is, after this article came out on Balkan, I have it on my retweeted Balkan Insights. I do think that there will be an investigation into this because there are a crazy amount of like economic interests on that. So if it passes like it does right now, I really hope not. I would expect people are going to sue. And yeah. Yeah, so I feel that, I mean, I know I'm not as up to date in relation to this as with the other, the crypto stuff, but I do assume that you can have a suit the moment, and people are already preparing for it. You can prepare it and then file it. Because the proportionality argument is missing. It's not proportional to what they're trying to do, and also there isn't any indication that the crime reduces by scanning. I mean, you know this probably much better. So,
can you elaborate a bit more on why it was so critical that they used a credit card to buy the GitHub account? Why is that significant?
You know, I don't think it's significant. But they, in the indictment, make it significant. One reason why they say it's significant, in the conspiracy to operate the unlicensed money transmitter, what you need to do to have a conspiracy, usually, you have two things. You need an overt underlying act. You need an overt act. And what they said here is the overt act was using the funds transfer via the credit card in a US account. So they basically used it to be able to, in their opinion, in their mind, meet the conspiracy offense. Because they want to use a conspiracy because it has a lot of evidential and prosecutorial advantages. So they use it, and they needed the credit card, but they also used it for just to show that they're running Tornado Cash. Like all this, like you needed to show that somehow it's a US bank, and that you use a credit card, and the credit card is linked to the US company, and then in the name of the Romans. Yeah. I think it needs to, in court, and there needs to be an argument over how important it is that you use the damn credit card on your GitHub. So.
Any other questions? Do we have time for? I will ask a quick question. I'm just wondering, like you mentioned that this FATF institution is using soft law, and it's very difficult to challenge legally. And yet there is this kind of creep where it's becoming globally accepted regulation, and various countries are like beginning to mimic the others, and with very little democratic process. And I'm just wondering if you have thoughts on, what are the possible ways to counter that drift towards total financial surveillance?
I think that we need to look into like how actually to catch the criminals. Like, yes, going after the money is a good idea, but it cannot be. It seems at the moment it's mainly the only one. the problem is that basically the cost of this is outsourced to the banks. If you now needed to increase law enforcement to look into the underlying crimes, then the state would have to pay for this, and you need to consider how the citizens pay for this. Right now, the costs are outsourced to the banks, so this makes it difficult. There's also an economic incentive to have it done that way, and why it's liked so much everywhere. I think we need to look into have some. This is not my idea. A lot of experts have said that already. Look at how efficient this has been. It's one of the least efficient things they ever have done and really affect our privacy law. So we have to look at these are the costs. This is what comes out of this. We have less than 1% of funds saved in this system, and you just exporting this to the crypto system where you can't even erase the data, and so it's a two-ball game here. So I think there needs to be a discussion on how FATF can be renewed just by lobbying, by writing more about that, by trying to sue, by impact litigation. That's what I think.